Van Dyke versus U.S. Bank.
I may reserve 5 minutes, Your Honor.
5 minutes, sure.
Thank you. My name is Jonathan Robin. I'm joined by Jacqueline DeChico. We represent the appellant, U.S. Bank. I'm going to skip right to the facts of our case because I've listened to Your Honor's arguments and heard where you're going, and so I want to get to why our case is a bit different and why Section 7 does not apply.
Are Section 4 and Section 8 squarely implicated here, and if so, how?
Section 4 and Section 8 are implicated if the court determines that Section 7 applies. Either one of two things happened, Your Honor. Either the case in 2009 was a nullity, or Section 4 and 8 apply because in 2022 it was discontinued, making it under Engel a nullity.
And I think there's an argument that maybe you distinguished a case with Section 4 and Section 8 below. You don't view that as taking that argument and those issues off the table?
I do not believe it's taking it off the table.
Why is that?
Because I believe, first off, we raised it below, and we talked.
Oh, one can raise an argument and then later abandon it. I think that's the suggestion.
I don't believe it was abandoned. I believe we raised it in both the lower court as well as the appellate division. And while we focused on the fact that the predecessor plaintiff lacks standing, we also know
Section 7
under Section 7 under the argument they're making under Section 7, we noted that we still discontinued it prior to the passage of FAPA.
What about the September 10th letter? I think you know what I mean.
Yes.
Why doesn't that accelerate the loan as of that date?
Because as Your Honor has made clear in Engel under the Vargas decision, that letter was not an overt act. Yes, there was.
Why not?
Because all it did was provide information, as Your Honor said.
Well, except the information is $435,000 due. It's not a monthly payment due.
But it said that they could make the payment. It also said that there was a pending.
Which
it provided
payment? I'm sorry,
information.
what payment could they make?
They could pay the amount that was due.
The $435,000?
That had been.
That's the accelerated amount.
Had been previously accelerated by a party without acceleration.
Yeah, but the point this letter comes, you now hold the note, no? Or at least the party on whose behalf Auckland sent the letter, owned the note.
A party owned the note, yes.
Well, that party.
Yeah, that party, yes.
Right.
Yes.
So there's no question that when this note was sent.
When the letter was sent.
Sorry, when the letter was sent, yes, thanks for correcting me. When the letter was sent.
Yes.
There was no question that they had the authority to send the letter.
Correct.
Okay.
I'm not questioning the authority
Yes.
on that.
So why doesn't that accelerate the debt?
That would, assuming that accelerated the debt, which, again, I don't think it did.
Okay.
Then we go to the Section 4 and 8 issue that we have because we then de-accelerated the debt by discontinuing the action.
No, that only
Thereafter.
that only works for actions for foreclosures. Sorry, for statute of limitations that are started by a foreclosure action, right? Not for ones that are started by a letter. I don't think it reads that way.
But I also don't, while Engel did make clear that a action could be started by a letter, I am not aware of what such letters exist because it has to be.
Well, I guess the question is this such a letter?
I don't view that as an overt act.
It appears to be asking for payment of the entire accelerated amount at a time when the person who sent the letter or on whose authority the letter was sent had the legal right, was the counterpart to the contract. And I take your point about 4 and 8, but that seems to only apply as to foreclosure actions, and this would not be an acceleration by a foreclosure action, but by a letter.
So that letter informed respondent, I agreed, of the total amount that was due. It indicated that it could choose to pay off the loan.
Well, does it give it any other option? We'll send it to debt collection otherwise for the whole amount. It doesn't say you can pay an installment.
But it doesn't say that.
You can't? I think it does.
It does, but it also doesn't say that there's no indication of a future foreclosure action. There's no indication of, it simply says you're in foreclosure. This is how much is owed. And
Okay.
thereafter, a discontinuance was filed, which, as this court has made clear, that equates to a deacceleration.
When was that done?
The discontinuance,
Yeah,
that was done in 2022, I believe.
so it was more than
It wa-
6 years?
It was more than 6 years after.
So aren't you out of the box there, too?
No, because the court in Angle did not say that the deacceleration had to be done within 6 years. I think that would be reading too much into that. Courts, unfortunately, foreclosure cases in New York take longer than 6 years.
I'm a little confused. I thought the de-acceleration was the attempt to stop the statutory time limit. Have I misunderstood?
The deacceleration brings it back to zero. That was what the court in Angle said. A deacceleration it annuls any
Yes,
actions.
but that,
It's as if
getting to zero only has meaning if you've actually stopped the prior clock. Otherwise, it doesn't matter.
Correct. But if it annuls an action as if no actions have ever been taken, it doesn't matter if it's done within 6 years or not, because no action was ever taken to begin with.
I don't think one would call it a de-acceleration when it's a nullification, but okay.
Well, no, but I'm talking about the discontinuance now, not the
Yes.
not the nullification.
I see.
So what I said is that either the action that was started was a nullity to begin with because it was started by a party without,
Okay.
or if Your Honor takes the position that the letter accelerated, there was a de-acceleration in 2022 prior to the passage of FAPA, when the notice of stipulation of discontinuance, which I emphasize is different than the notice of discontinuance in Angle, because in this case, it is not a unilateral discontinuance, it is a joint discontinuance. The parties agreed to discontinue. And the reason the parties agreed to discontinue, in this particular case, the 2009 action, as compared to a notice of discontinuance, was because it was determined that that plaintiff lacked standing. And so the parties went ahead, they stipulated to it, both parties signed the stipulation, and then actually went a step further and got the court to so order that stipulation.
Right, but my issue is that 4A, which I think is what you're turning to, applies only to accelerations that happen because of the initiation of a foreclosure action. And if we think that there's an acceleration here that was initiated by the letter, I don't see that the stipulation matters.
Well, I would argue that the overt act still would be undone by the stipulation of discontinuance, which says that we are bringing this back to zero. That was the intent of the stipulation of discontinuance.
But the wording of the stipulation of discontinuance, I think, is also framed in terms of foreclosure action, not a letter.
Understood. Regardless, a new foreclosure action in our case was started prior to the passage of FAPA. So this goes to the questioning as to the timing that you were asking prior counsel on. And what's important with the retroactivity and the question as to timing is that this court has consistently held in Chu and in other cases that parties should be allowed to rely on the law that is in effect at the time it does its actions.
Well, what is the vested right? How would you define the vested right or rights that you're
Our
now
vested
invoking?
rights
Yeah.
would be twofold. One, we have the property interest right in the mortgage contract, but we also have a vested right the moment we bring that litigation.
In what?
In the litigation, in the actual foreclosure
You have a
action.
vested right in litigation?
Yes, this court held so in 1832
Oh, wow.
in the,
I guess I wasn't there.
He wasn't paying
nor
attention.
nor was I, Your Honor. But it said it's a general rule, yada, yada, yada. It says,
That's the part we're going to quote. That yada, yada,
no,
yada.
no.
So you know.
It may have such retrospect, but not to take away a right of action which the plaintiff was entitled to before the time of its commencement. So before the time of the statute's commencement, we were entitled to bring a new foreclosure action. FAPA cannot take that right away,
And what are you basing that on? What's your authority for you were able to do that?
that we're able to bring the
Yeah,
action.
to bring the action.
Yeah.
Are you talking about the law before Engel?
I'm talking, yes, the law has been the law in this country, or in this state, excuse me, for over 100 years. The law before Engel was the same as the law after Engel. Engel did not make new law. Engel reaffirmed the law. Engel was clear on that. Engel was clear that the law had been that way since the Loeb case, since Albertina, for centuries.
I might read Engel a little differently, because I think we said in Engel that no clear rule had emerged before, but,
You
okay,
said
go
in
ahead.
respectfully, you said in Engel that no clear rule as to what constituted a deacceleration, not that it could not be deaccelerated. And what you said was that you had never looked at whether a notice of discontinuance constituted a deacceleration, and that you determined that a notice of discontinuance did in fact constitute a deacceleration. And so that's the distinction. Back to the question as to the vested right, we had it all of the actions in this case, every single thing that took place before FAPA. Applying FAPA to undo what my client, the appellant, relied on.
That's not inviolate, though, right? Isn't that, to the extent, you're saying that you had a vested right in the action,
Yes.
right? And if that were to be correct, even then, that right wouldn't be inviolate, would it?
Wouldn't it be what?
The legislature could adopt a statute that would have retroactive effect that might impact the extent of your right, and then it would be subject to some scrutiny. But are you arguing that the legislature lacks all power?
I am not, the legislature can do what it sees fit, but it's this court's job to make sure it doesn't extend its power. And I think it goes beyond what it can do when it retroactively removes a vested right.
But
And if
retroactivity is permissible but needs to meet certain standards. Would you agree with that?
Yes.
Okay, and so why is it that that would not be satisfied here? Because I took you to be saying that the legislature simply could not act at all, and it strikes me that perhaps the question is a little bit different, which is, if we were to agree that you had some vested right, was it impermissibly impaired?
Yeah, and the law, my understanding, and again, is that it's unconstitutional, whereas here, it deprives one of this right retroactively. A statute, if it cannot take away a vested right in any situation.
And
I
again,
think.
what's the vested right that was taken away here?
So in our case, it's two things. One, it's the property right that we have via the mortgage, but it's also the litigation that's pending. The prior action that we filed before the passage of FAPA,
Was that the 2022
the
litigation?
2022 litigation.
But wasn't it untimely in 2022? Because
No.
more than 6 years had passed since Bank of New York had filed theirs?
No, it
Why
was,
not?
because Bank of New York was not if we just take FAPA off the board, Bank of New York was not the proper party. We would have the ability, and again, a court could theoretically still find that Bank of New York was the proper party, and they had the authority to accelerate, and therefore our action is time barred. But both lower court and the appellate division determined that we were unable to establish, or not Bank of New York was unable to establish its standing to foreclose, and it was not the proper party. Therefore, when it was discontinued because it was not the proper party. If it was not the proper party,
Well, did they make an explicit finding, or didn't they just say, we can't make a finding at this point, and we need more evidentiary evidence, so go back and figure it out?
they did.
Right, so that's very different than a finding.
But at the time, you did not need an explicit finding. When that decision was made in 2022, there was no requirement that it be an explicit finding. We would have been able to argue it every day of the week.
But you're arguing now that there was a finding that they didn't have standing, and I'm just saying there wasn't a finding that they didn't have standing.
Well, there was a finding that they weren't able to prove standing. which I understand there is a distinction there, but there still was that finding. And to say you should have argued, you should have.
That was on a motion for summary judgment?
Yes,
We don't usually think of those as findings, right? We think of those as absence of proof to meet the summary judgment standard, but that means there's issues to be tried.
correct. And again, not to say that the problem is we will never, because of FAPA, even be allowed to argue that anymore. When we made the decision not to litigate the case, it was because at that time the rule was you could bring it up with the proper party. FAPA has stripped that right away from us because now it says, no, you can't even raise that.
Thank you.
Thank you.
May it please the court. Tom Curtis for Patty Van Dyke. I'm going to address one issue first, and that has to do with the decisions of the courts below on summary judgment. It's not just two decisions that denied the Boney summary judgment. It was my motion as well, asking for summary judgment to dismiss the case on the lack of standing, which was denied by the court below in Bronx Supreme and the First Department. The First Department decision on that issue is law of the case. There was no decision denying, or no decision holding that Boney did not have standing. It was reserved for trial. And this is the false narrative that runs through appellants' papers, because it's absolutely untrue. It's Hornbook law that a motion that's denied on summary judgment reserves the issue for trial. Now, that means also that the action could only be annulled had there been a dismissal on the merits of that case. That is, that there was no standing. Otherwise, there's nothing to annul. Okay? You can't withdraw something that didn't happen in the first place. So either they are still, that is, it's been decided that Boney had the opportunity at trial to show that it had standing. And the fact of the matter is, and I know this from the history of the case since 2009, Boney had a problem with that issue in the first place. The note was not attached to the complaint in the Boney action. And that's the first tip-off to a lawyer. Now, I will say that I'm in favor of borrowers paying their lender. But that's not what this is about here. This is about a lawyer's duty to a client to expose a bad case. And in fact, when there is a bad case, a lawyer's supposed to deal with that in an appropriate way, which is raise the defense. It's an affirmative defense. So now, when that defense was raised, Boney was on notice that they had an issue. They moved for summary judgment in 2014, and they lost. And it's quite clear what the terms of losing were. They failed to annex the documents which supported the affidavit, and the affidavit was as wishy-washy as you could get. They were given an opportunity to come back. At that time, we had already tried to settle the case several times without effect, and because I knew there was a flaw here, they could have easily withdrawn the case at that time within the statute of limitations, refiled, and my client would have been on the hook for the whole mortgage. There's no question about that. The lawyers screwed up here. They sat on their butts and did nothing.
So by 2022, it's your position here.
I'm sorry?
Right here, counsel. So by 2022, it's your position that they're out of luck and out of time.
I'm sorry, I'm not understanding you.
So by 2022, when they're bringing the foreclosure action, it's your position that it's completely untimely?
Not only is that completely untimely, but they lie like hell in that foreclosure complaint because they claim that my
right,
client
well-
stopped paying in 2018, when we all know she stopped paying in 2009.
Might not matter if it's untimely.
I'm sorry?
I mean, the lies might not matter if it's already untimely, right? The lies may, whatever these lies, alleged lies are, do they matter to the timeliness assessment?
I'm sorry, whatever the lies,
What you say are the alleged lies, do they address the question of timeliness?
yes, they claim that she defaulted on the loan in 2018, or it's 2016, not 2009. All right, it's a misstatement in this new foreclosure that really is unfortunate in the sense that a lawyer certified to the truth of the facts, which is reason for having FAPA enforced, because lawyers
So, as I understand it, in fact, your client had not been paying rent.
I can't hear you, Your Honor.
In fact, your client had not been paying rent or mortgage payments at all since 2009.
Not since 2009, not a dime.
And they made it seem like she actually was
And they made it
paying.
seem like she had, yes.
Okay.
Yes. And so I haven't addressed that. They also served me instead of serving her with the requisite notice on the foreclosure, and I moved to dismiss on that ground, and Justice Gonzalez said that the service was acceptable because I was her attorney in fact. So, I mean, that was a very limited motion here. Let me get to what this case is really all about. When I drafted this complaint, I knew there was an issue that might be raised regarding the validity of the Boney action. Now, the note and mortgage were assigned about 3 weeks after the action was commenced on October 30th. They was assigned as a matter of record, and that assignment's very careful to include the note. It's in your record on appeal. And when that assignment took place, Boney had the authority to do whatever it wanted to do because it demonstrably was the owner of the note and mortgage.
And that's of about December, I think, December 1st?
That was December, yes.
Yep.
Yes. And
So that happened, that's Bank of New York got the note December of 2009, right? Which is before the letter
Correct.
that we referred to was sent?
Correct.
By about 9 months.
By about 9 months, correct. And that letter was sent, and that letter is in no way, shape, or form similar to the Vargas letter, which you decided in Engel did not require an immediate payment of the full principal and interest. That Vargas letter is in our record. I think it's at page 222. I'm doing this from memory. But we have a similar letter that was sent in early 2009, in May, I believe, of 2009, that corresponds to the Vargas letter in Engel. And what it does is it threatens to bring a foreclosure action in the event that you don't resume payments and pay the loan on a regular basis. Now, the 2010 letter does not say that at all. It demands payment of principal and interest, and it does not give an opportunity to reinstate the loan and to offer to forego an acceleration or anything or demanding full payment because the note and mortgage, which is the contract here, does not use the word acceleration. All it uses is a demand for payment in full. So this letter does not offer that exception like the Vargas letter offered. It demands payment in full, and then it does like it does for every other closing where you want a payoff statement. It says you'll pay interest until the date you pay off the entire amount. Now, this action comes here on a motion to dismiss the plaintiff's complaint. And in order to hold the complaint sufficient, you have to decide that this letter demands payment in full, okay? And that it's an unequivocal demand for payment in full. Now, there's another reason to hold that it's an unequivocal demand payment in full. It's because there's admission against interest by U.S. Bank, because we have an affidavit saying they accelerated the loan. And that affidavit is provided by a senior vice president of Rushmore, who also attached an affidavit, it's in the record, showing, not an affidavit, a power of attorney, that he was acting for U.S. Bank. Now, it seems to me it's rather impossible to hold that they didn't accelerate the loan and demand full payment if there's an affidavit from U.S. Bank's representative that that's exactly what they did. Now, there's another reason for holding this letter to be an effective demand for full payment. Not every lender wants to foreclose. There are times when a lender may decide to bring an action on the note. And if you can't make this a letter that demands full payment, how, under the standard Freddie Mac Fannie Mae documents, do you establish that you are demanding full payment if you haven't foreclosed? Because I can give you a case involving Stewart Title where they brought an action in foreclosure, wanted to withdraw it and substitute a complaint instead for an action on the note. And that case citation is Stewart Title v. Zaltzman. It's not in my brief. It was an afterthought. Second Department, 208 AD 3rd 916.
Counsel, what do you get at the end of a successful action on the note? Is it just a judgment?
You get a judgment against any asset that the defendant has, which, if you have a wealthy defendant and a property that's underwater, you might choose to sue on the note instead of suing them on the mortgage. And you have to elect your remedy here. And so if you get delivery of the note and you choose to do that, you still have to notify under Article 7 in the note, the standard Fannie Mae Freddie Mac note. Article 7 tells them, the borrower, that they can accelerate, that is, they can demand full payment, okay? And how would you do that if you don't say that this is a demand for full payment? Because if you're suing on the note, you're just going to sue seeking summary judgment right away without all the nonsense of the foreclosure action, and you're going to go after all the other assets, which is the choice of the lender.
I might regret this question, but I'm looking at the letter, and it says in it, this letter is in no way intended as a payoff statement for your mortgage. It merely states the amount of the debt as of the date of this letter.
Judge Singas,
Yes.
that's in every closing that you go to. You get a payoff letter, and it says that they're going to increase the interest until the actual funds are deposited by the party. So that is until it's cleared, until cleared funds have been paid. So the interest item is a moving target. And there is no way that any lender would agree to accept the principal and interest to a day and then forego interest until they actually receive the funds. So that is not a condition here that would change the aspect of this letter, which is you have to pay us in full, okay? Because, first of all, this is a contract action. And under contract law, you look at the terms of the contract. If it's unambiguous, then you have to apply the contract as it's written. Now, nowhere in that Fannie Mae Freddie Mac documents does it say if you offer to pay the due amount on the due date, you're going to not have to pay interest afterwards. You pay interest until the day you actually make payment. So that being said, unless there are more questions about this document, I would like to address the FAPA issue.
Sure, please do.
So, Two things. The court should follow its decision in Police Benevolent Association v. City of New York and Glen Oaks Village of City of New York, again, versus City of New York. And there the key question was, what did the legislature intend? Now, you've been asked those questions before. You've gone back and forth on it. So I don't want to get more into that. I want to go to some other parts of this because the fact of the matter is that I think you know what the legislature intended. What we have here is the reality that there was no proof that that Boney could not provide a witness who would testify as to the delivery of the note prior to the commencement of the action. And so at the time the stipulation of discontinuance was presented for my signature, I refused the first several drafts. That stipulation reflects the fact only that summary judgment motions were denied. That's what it says. It does not, in any way, shape, or form, reflect anything else. And it was done as an accommodation to Judge Gonzalez, who didn't want to try this case because we all knew that they didn't have a witness, a credible witness, to testify. And how did I know that? Because I had deposed Boney's, that is Rushmore, and I knew from the deposition that they had no witness. And that being...
Counsel, your time is up, if you'd wrap up.
Okay, so the fact of the matter is that withdrawal of the action was for the convenience of the court and parties, and not to allow the plaintiff to get out of a trial scot-free. He would have lost the trial, for sure. Okay, so you can't look at that as a nullification of the standing issue when there's no proof that Boney didn't have standing. Had they had a witness, they would have had standing.
Thank you.
Thank you.
May it please the court, Mark Rube for the Office of the Attorney General. I'd like to address a few distinct constitutional questions in this case.
Can I ask you first, counsel, what provisions of FAPA do you think are properly before us in this case?
I think that all of the FAPA provisions are properly before you. We flagged that there's an issue with respect to 4 and 8. They did raise it. The courts below did address it. I think the cursory nature in which they raised it below caused some confusion. And so I think the courts below didn't get the point that you cannot do this discontinuance 6 years, more than 6 years after the statute of limitations has run. That wasn't the law under Engel. That wasn't the law before Engel. That wasn't ever the law. And I'm surprised to hear counsel take that position because it would give lenders the opportunity to unilaterally restart the statute of limitations at any point, and then there would be no statute of limitations. And notably in Article 13, the district court addressed this issue. It was a similar posture. There was in Article 13, the first action was in 2007. It was discontinued in 2017. The district court said that's too late to restart under Engel, and the other counsel for U.S. Bank never challenged that on appeal. And I think it's a fairly, so that makes the Engel issue, the 4 and 8 issue, fairly straightforward. As a textual matter, they apply to this case. And in terms of vested rights, there never was any right at any point in time.
Why not?
Because there would, so first of all, there was no right in a common law rule. There was never any common law rule that held that you could restart the statute of limitations more than 6 years after it had already run. I do want to address Kilpatrick, which they talk about creating this 100-year tradition of deacceleration. So in Kilpatrick, it had nothing to do with the statute of limitations, and the court actually held that the lender could not revoke the acceleration in that case. So how this stands for a 100-year tradition of acceleration, let alone restarting the statute of limitations, I don't know. The statute of limitations issue did not really percolate until the mortgage foreclosure crisis, where we had these cases in 2007, 2009 with inadequate documentation. We're getting to around 6 years later, 2013, 2015, and some clever lawyers need to figure out how are we going to deal with this problem. They have a clear mechanism. The General Obligations Law since the 1960s has provided a mechanism for restarting the statute of limitations. They chose not to pursue that clear rule, and they took the risk that we can unilaterally deaccelerate and claim that that restarts the statute of limitations. And the fact that they took their risk on a contested point of law, that does not give rise to a constitutional right or a constitutional injury. I do want to address the timing question that I didn't get to in Article 13, because I think there's some confusion about what point in time this court looks to as to whether there is a constitutional right. So we have a contracts clause claim in this case, so that's pretty clear. The court looks to when the parties executed the contract. And as for the due process question, the United States Supreme Court has said that the court looks to, would appellant's conduct have been different if it had known the rule in advance? So we're not talking about when you file a complaint hoping that the law will stay the same, otherwise you can never have retroactive legislation. Rather, we're talking about when they acted. So with respect to Section 7, when the initial representation was made to the court, was there a reasonable belief that they could disavow that at a later point in time? Or with respect to Engel in Section 4 and 8, when the discontinuance was made, often in 2013, 2015, could they have relied on that? Here, the discontinuance was in 2022 and has a distinct problem that it was just already too late. But that's sort of the substantive due process issue. I would like to...
Why aren't they entitled to a grace period?
Sure. So the grace period applies in Brothers v. Florence when the statute of limitations was changed from, say, 6 to 3 years. So if you're somewhere in this period between 3 and 6 years, you didn't have a chance to file a timely claim, and the court said, we will give you a grace period. Here, we're talking about defaults from 2007, 2009. There's been ample opportunity for banks to foreclose and participate, and they've had ample incentive to do so since they haven't been paid on the note since 2007, 2009. And so there's no need for an additional grace period beyond the already
Suppose they
years
had filed suit within a 6 period, just hypothetically. Would they be entitled to a grace period then?
Well, that situation is unlikely to happen because before 2021, there was no reasonable reliance on the Engel rule. As Your Honor noted, no clear rule had emerged at that time. And so for cases after Engel, perhaps there would be a different analysis, but I'm not really aware of many cases because Engel happened in 2021. So if you go back 6 years, it would be 2015 or later that somebody could theoretically have relied on the Engel rule, but by that time you already had the certificate of merit requirement. We've already solved a lot of these problems. So these problems are really reaching far back in time where there was no clear rule and they've had ample time and don't need a grace period. I'd be happy to briefly address the contracts clause claim, but I know my red light is on. So.
Why don't you take a minute?
Okay, so on the contracts clause, first of all, the question is whether there's an express term. There is not. The only deacceleration term is that the borrower can reinstate the loan under certain conditions, but there's no provision for the lender. Then the question of whether there's an implied right, I think this is important because federal courts look to this court's guidance on this question. The U.S. Supreme Court has said that while federal courts analyze it on their own, background principles of state contract law, we will defer to the state high court. And so there's no implied right here because, as we've discussed, there was no settled rule at that time. And what an implied right looks to, and I don't want to go in too far, but I just want to talk about a seminal Supreme Court case on this, looked at negotiations between General Motors and a labor union. And the court was looking at, these are hard-fought negotiations between the parties, and was looking at if there's a background principle of state statutory law, does that take that issue off the table and affect the back and forth of the negotiation? And this context is the complete opposite. These are form contracts that are take it or leave it agreements, purposely so that they can be sold. And so there's no back and forth negotiation, so there's no implied right. And just finally, the court has recognized that when the state is not a party to the contract, we're talking about contracts between two private parties, that there's a lot of deference to the legislature in terms of whether it's a legitimate purpose and rational goals. And for the reasons I've talked about with respect to the due process analysis, the tailoring analysis under the Contracts Clause is the same. So unless there's any further questions, we ask that you reject the constitutional challenges to FAPA.
Thank you.
The AG's office just talked about, would the conduct have been different had the parties known the law? And Respondents' Counsel made very clear that the very reason for the discontinuance in the 2009 action was because the judge knew that Boney could not establish its standing. Had we known at that time that we later could not make that argument, we would have wasted the judicial resources and litigated to the fact that Boney can't. We didn't know that legislature months later would pass a law that says now you can no longer argue, despite the fact that respondent argued for years.
I'm not sure what you meant by waste judicial resources.
Well, because as Judge Gonzalez made clear, she didn't want to litigate a case that she knew Boney couldn't prove.
Well, I guess more to the point is whether you knew you couldn't
Well, we
prove
knew
it.
we couldn't prove it too, so that's why we stipulated to discontinue it. And had we known at the time,
Well, presumably you knew you couldn't prove it 10 years before that.
no, that we thought that we had sufficient evidence, and the court determined that that evidence was insufficient.
And determined that still when? Within the statute of limitations period?
Yes. Well, arguably, again, we were at the behest of the judicial system and the length of time that it took. So I would say it was still within the period because, again, if we did not have standing to begin with,
So you're saying the process was slowed because of the judicial system itself and not because of decisions, litigation strategies that were taken?
I mean, motions for summary, yes. I mean, it takes time. Unfortunately,
But if people litigate expeditiously, they can be resolved expeditiously.
at times, but unfortunately, decisions also take time to get.
Doesn't take that much time if people pursue the cases expeditiously.
I mean, you're talking
Understood.
about 13 years here,
Yeah,
right?
and I'm not saying it took 13 years. What I'm saying is the process, we let the process play out as soon as it became apparent that we were not able to establish, based on the law that was in effect at that time, the parties made a decision to discontinue the action.
When you say the law, do you mean common law or statutory law that was in existence?
Statutory law. There was no statutory law that said, zero statute that said, you cannot raise the argument, you are stopped from raising an argument that a predecessor lacks standing. This, Section 7 of FAPA, codified at CPLR 213-4, that is new law. That did not exist before FAPA.
Was there a law at the time the suit was filed that said you had to hold the note to be able to start the foreclosure action?
There was, yes.
And it looks like the record we have shows that you didn't have the note.
Not we.
Bank of New York didn't have the note.
Yeah, Bank of New York did not have the
So-
note. So
is
then
it
it would be, then under this
Right,
court's
and so I'm
jurisdiction,
sorry.
that it's a nullity.
You don't have my question yet.
Sorry.
So when was it that you found out that Bank of New York didn't have the note until December?
I am not
Was
aware.
it within the limitations period?
I I do not have that answer,
Okay.
Your Honor. I apologize.
No, it's all right. So why, do you know why it was you thought you had sufficient evidence to win on summary judgment?
I believe that I was not the attorney
Okay.
at the time.
Fine, fair enough.
And so I defer to that.
Okay.
Regardless, applying Section 7 retroactively changes the calculus for my client. I briefly want to discuss the letter. A couple things. It's at the record on page 118. It is an informational letter that was sent by a servicer. There is, as Justice Seagate pointed out, there is no demand in here for payment. There is no requirement that payment be made. There is no statement of any time saying you must make this payment. There is no overt act, as this court has said, must be done. So this letter,
$450,000, if you don't pay, this is going to debt collection? You owe this money right now, overdue?
please be advised, yeah, it says this is what you owed, but it doesn't say this is an overt act. There is no, the overt act
What
that
would,
this
what
court
would it
is-
have to say? This is an overt act?
No, it would have to say, we are seeking, I'm sorry.
You say informational, what's the point of it?
What is, it's required,
I've just decided.
it's required under the Fair Debt Collection Practice Act.
But why would it be required, if not
Because
to let,
Under 1692G, which is under the Fair Debt Collection
yes.
Practice Act,
Yes.
Ocwen has to send this informational letter as it is the servicer for the,
there's a purpose behind, there's a point
But
to the notification,
it's to provide the information to the borrower.
so they know how to act, which the act is
So
to
the-
pay.
The act is to pay, but that is not, it is not an overt act. As this court stated in Angle, there had to be a specific overt act, and I take the position that this is not that. Thank you.
Thank you.